Ready, start. Legislative omission, whether absolute or relative, strikes at the very root of this realization by creating voids that impede the enforcement of fundamental rights. The Constitution entrusts this court with the solemn duty to act when such voids result in the denial of equality, dignity, and non discrimination. The present case exemplifies how the silence of the legislature and the inaction of the executive in implementing the mandate of the 2019 Act and the 2020 rules have perpetuated systemic exclusion of transgender persons. The failure of the appropriate government to formulate inclusive policies constitute redressal mechanisms and ensure safe and equitable access to educational and employment opportunities constitutes not a mere administrative lapse but a violation of the constitutional rights. It is therefore incumbent upon this court to remind the state that the promise of equality under the Constitution is not a passive assurance but an active obligation, one that demands continuous vigilance and affirmative measures to translate the guarantees of the Constitution into tangible and transformative realities for all persons, including transgender individuals. The question as to whom fundamental rights bind or constrain would flow as a necessary consequence of the distinction underlying the single inverted comma vertical single inverted comma close and single inverted comma horizontal single inverted comma close effect of such rights. When fundamental rights are said to have a vertical effect, they apply only between the individual and the state, thereby limiting how the state may act towards its citizens. In contradistinction, when rights are understood to have a horizontal effect, they extend to relationships between private individuals or entities, ensuring that constitutional values such as equality, dignity, and non discrimination are also respected in private interactions, be it in employment, housing, education, or access to public spaces. The 2019 Act represents a significant step towards giving horizontal application to constitutional rights in India. Section 3 of the 2019 Act expressly prohibits discrimination in a wide range of social and economic spheres, namely employment, education, healthcare, and access to public or private spaces. In doing so, Section 3 extends the guarantees of equality and dignity enshrined under Articles 14, 15, and 21 of the Constitution, respectively, in the private sphere. By creating statutory obligations for non state actors, the 2019 Act translates the constitutional promise of equality into a social duty mandating inclusion beyond state instrumentalities. However, while the Act operationalizes the horizontal effect of constitutional rights in form, its limited enforcement mechanisms often weaken its transformative potential. In light of the 2019 Act explicitly manifesting the horizontal application of fundamental rights, a reconciliation of the debated controversy over whether fundamental rights can have horizontal application becomes largely academic in this context, since the legislature has itself already imposed obligations upon non-state actors to guarantee the non-discrimination against transgender persons who continue to be victims of prejudice, stigma, and social stratification. This legislative trend is not novel. In furtherance of this endeavor to realize the ideals underlying our fundamental rights, the Parliament has consistently enacted several legislations that protect marginalized communities and disadvantaged persons even within non-state spaces, thereby democratizing access and opportunity.